My name is Stefano Burchi, and I am Chair Emeritus of the International Association for Water Law, also known as AIDA after its acronym in Spanish, and Chairperson of the Water and Wetlands Law Specialist Group of the World Commission on Environmental Law of IUCN, the International Union for the Conservation of Nature. Good morning, good afternoon, or good evening from wherever you are connecting, and welcome to the webinar Towards Freshwater Rule of Law, a Manifesto of Fundamental Principles. This webinar has been convened jointly by the World Commission on Environmental Law of IUCN, AIDA, and the Environmental Law Institute to illustrate the fundamental freshwater rule of law principles that are encapsulated in the Manifesto for the freshwater rule of law, the current text of which is accessible via the link provided in the webinar flyer, and B, collect preliminary feedback on the basis of a number of guiding questions which will be posed to you later in the course of this webinar. Comments are also invited after the webinar and should be sent to the contacts that will be shared at the end of the webinar. Let me begin by contextualizing the Manifesto initiative. The Manifesto for the Freshwater Rule of Law is the work of a small team of water law experts who are members of the WCEL Water and Wetlands Law Specialist Group that I chair, and of the International Association for Water Law, AIDA, at the same time. The Manifesto calls attention and is meant to inspire action by national policy and lawmakers and other stakeholders to focus on domestic legislation as a key pillar of achieving and operationalizing the freshwater rule of law. The conceptualization of the freshwater rule of law, and in particular the principles encapsulated in the Manifesto, are in response to several persistent issues that are central to effective, inclusive, and sustainable domestic freshwater governance. The Manifesto also resonates with the principles and core values of the Brasilia Declaration of Judges on Water Justice issued by the World Commission on Environmental Law and adopted at the 8th World Water Forum held in Brasilia in 2018. The freshwater rule of law concept is fleshed out in the Manifesto through 10 principles, which build on more traditional conceptualizations of the rule of law, as well as on evolving concepts of the environmental rule of law. The principles are intended to provide guidance for countries to analyze and diagnose where the freshwater rule of law can be improved to foster more equitable and sustainable water resources governance in line with human rights and the Sustainable Development Goals. An intense consultative process, beginning with this webinar, is planned in the months to come for refining the principles and preparing an accompanying explanatory memorandum. Moreover, the intention is to develop indicators and a framework for assessing where countries stand with respect to the principles, and to identify evidence-based good practices, tools, and approaches that can be adapted to countries' specific contexts to achieve more effective integration, implementation, and enforcement, eventually, of water and water-related legislation and regulations. Further analytical work will aim to develop innovative legal and regulatory solutions to identified issues. The ultimate goal is to engage with countries, to build capacity to elaborate and apply an assessment work framework, analyze gaps and issues, and determine the appropriate and practical mechanisms for improving the freshwater rule of law at the national level. Let us now begin by illustrating the principles featured in the manifesto, which in the interest of time will be presented in clusters and not sequentially. Roberto, may I have now slide principle number 1 on screen, please? Principle 1 of the manifesto for the freshwater rule of law is styled integration and coherence of domestic freshwater-related legislation and is perhaps the overarching principle of the manifesto. It reads as follows. Domestic freshwater-related legislation should reflect the complex web of interactions between freshwater, watershed ecosystems, and the multiple uses that sustain life, human health, well-being, and development through sufficient and clear integration. Domestic water-related legislation should also be clear and coherent throughout the spectrum of regulated human actions that impact directly or indirectly on freshwater resources. This includes ensuring that domestic freshwater-related legislation supports effective intra- and inter-sectoral integration. This principle springs from awareness that freshwater does not exist in isolation from the wider natural environment where rivers, lakes, and aquifers underground form and live through the hydrologic cycle. The diverse and complex interdependencies that occur in nature across an integrated environmental continuum spanning from land to water resources, to the subsoil, and to other natural resources, speak to resource integration and to the desirability that this be reflected and promoted by integrated governance and legal structures. Water is also the primary medium through which the impacts of climate change are experienced across these sectors, posing critical challenges that require an integrated governance and legal response. The principle 1, emphasizes the imperative for domestic laws and regulations to be integrated and to bring coherence across the full extent of the domestic legal and regulatory spectrum of human actions that impact directly or indirectly on freshwater. This includes taking action in particular to ensure that legislation supports, as I said, as the principle says, more effective intra-sectoral integration and coherence vertically, and inter-sectoral integration and coherence horizontally. Integration and coherence of domestic freshwater-related laws and regulations vertically intra-sector require and implying bringing under one coherent normative roof, A, surface water and groundwater, B, the basic functions of water resources management, i.e., the allocation of available volumes and flows for use, and protection from pollution, reaching out to C, the protection of the watershed ecosystems where freshwater forms through the hydrologic cycle. Horizontal integration and coherence across the legal and regulatory spectrum of human actions that impact on freshwater or that are impacted by it require and imply that domestic water laws and regulations be aligned and coordinated with other strands of the domestic legal and regulatory framework, ensuring consistency and coherence of direction and purpose across them. Horizontal integration and coherence also require and imply that the laws and regulations that make up the domestic legal and regulatory environment impacting upon and being impacted upon by water and rights in water, and in particular, legislation on land use and on the use of the subsoil, including mining in particular, legislation on agriculture, forestry, energy, fisheries, be aligned and coordinated with domestic water laws and regulations. May I have the next slide, please, Roberto? Principle 9 on clarity and coordination of institutional roles and responsibilities is a direct spin-off of Principle 1 as is intimately linked to it. It reads as follows. Domestic freshwater-related legislation should clearly define the roles and responsibilities of freshwater-related and other relevant institutional mechanisms that are involved in its implementation and enforcement. Insofar as integration and coherence should be pursued across the full spectrum of domestic freshwater-specific and freshwater-related legislation, as called for by Principle 1, the respective roles and responsibilities of the governmental institutions and of the non-governmental actors that are involved in the implementation and in the enforcement eventually of the multiplicity of laws and regulations in effect in any one country need to be A, clearly defined in the legislation, and B, internally aligned and coordinated, ideally in a seamless fashion. This, lest confusion, overlap, and eventually conflict across governmental institutions, but also non-governmental actors ensue and stifle the effective implementation and enforcement of the complex web of laws and regulations that make up the legal framework for the governance and management of freshwater resources domestically in any one country, ultimately undermining the delivery of the custodianship responsibilities of government that are encapsulated in Principle 2 and that will be illustrated next. Let me now turn to Ms. Jessica Troell and to Ms. Robyn Stein, who will present the next group of principle.
Thank you so much, Stefano. Good morning, good afternoon, everyone. My name is Jessica Troell. I'm a senior attorney and I direct the International Water Program at the Environmental Law Institute, and it's wonderful to be with you all here today, sharing these principles. My colleague Robyn, Stein, and I will now share 3 principles which focus on the ways in which domestic water legislation governs the allocation, access, and use of fresh water, both substantively and procedurally. And these principles attempt to capture both generally accepted legal principles that have faced, as Stefano noted, significant challenges in implementation and enforcement, as well as more recently evolving consensus on water tenure as a framework for improving integrated, inclusive, and accountable freshwater allocation and governance. So I'll turn the floor over now to Robyn to explore the first of these 3.
Thank you, Jessica. Thank you, Jessica. And thank you, everybody, for being here. This is a wonderful opportunity to share a collective journey with you. I will be addressing Principle 2. This principle, as you will see on the screen, is rather multidimensional. The legal characterization of water as a public good is one of the cornerstones to the architecture of the freshwater rule of law as captured by the Manifesto. Let us now unstack these rich dimensions and texture of Principle 2. As a public good, freshwater resources are recognized as part of the commons. In other words, the legal character of freshwater resources is public, not proprietary. Principle 2 encourages a move away from legally conceptualizing freshwater resources as a privately ownable commodity and inspires their legal identification as a resource that belongs collectively to the people and is integral to and inseparable from the ecosystems that depend on it. The state is custodian, not an owner. Principle 2 recognizes an evolving doctrine of the role of the state as custodian of a nation's water resources, and in certain respects touches on some aspects of the public trust doctrine. The state holds freshwater resources in trust for present and future generations and must exercise fiduciary care, not dominion. Use rights are conditional and revocable. In a public resource framework, such as this, use entitlements are not absolute, but subject to the broad concerns of the collective public interest and sustainability of the resource itself. Noting, however, that these rights are not the sole provenance of the state and that customary and traditional rights should have legal recognition and protection. Public interest, referenced in Principle 2, includes people and by extension nature and its ecosystems. The state's duty of custodianship extends to the fulfillment of human rights, such as the access right to water and to ecological integrity. The public interest is indivisible. Human well-being cannot be separated from environmental protection and prevention of pollution. The custodian's duty is legislative and administrative. The state must give effect to its custodial role through law by enacting and implementing freshwater legislation and putting into place effective institutional arrangements that reflect equity, sustainability, and efficiency in allocation, use, development, and protection. Basic human and ecosystem needs should be prioritized. Principle 2 implies a shift to a normative hierarchy of use. In other words, the custodian must strive to balance competing uses, prioritize basic human needs and the ecological value and health of freshwater resources. And it must seek to align water governance with developmental imperatives. Climate change elevates the custodial burden. Principle 2 must be read in the context of climate risk. The state's duties now extend to climate-responsive governance, ensuring that legislative and institutional arrangements incorporate resilience, adaptation, and mitigation obligations. The custodian must act in anticipation, not in reaction. So in wrapping up and sewing together the numerous dimensions of Principle 2 in the context of developing a freshwater rule of law, it is apparent that custodianship in this context is not merely good governance. It represents an evolving justiciable duty pragmatically grounded in environmental rights, human rights, broader socioeconomic rights, and intergenerational justice. It is the legal mechanism whereby freshwater resources are characterized, as Principle 2 states in its chapeau, freshwater resources are characterized as a public good, thereby effectuating through the implementation of domestic freshwater and related legislation and the establishment of appropriate institutional arrangements, the allocation, use, management, and development of freshwater resources, including groundwater resources, and their conservation and protection from pollution in a manner that is legally and factually equitable, efficient, and sustainable. Thank you. Jess, I'll hand over to you now.
Thank you so much, Robyn. Roberto, if we could have the next slide. Oh, back one. Sorry. There you go. Okay. Building on what Robyn just very eloquently explain to you about the principle of water as a common good. I'll now talk a little bit about water tenure, which encompasses the rights, rules, and duties that regulate how fresh water is allocated, accessed, used, and managed. It's defined as the relationships, legally or customarily defined, between people as individuals or groups with respect to water resources. So water tenure, therefore, recognizes the rights and duties that emanate not only from state-issued laws, but also those that are created under indigenous and customary systems. This kind of legal pluralism is a characteristic of water governance across many countries that shapes not only who has access to and who can use water for what purposes, but also how the resource is managed and stewarded. This principle therefore highlights the important role of national water legislation in more clearly and effectively recognizing and protecting all legitimate water tenure rights and rights holders to ensure what Robyn referred to as distributive justice. This includes the need for more inclusive and accountable legal and administrative systems to recognize and protect these rights. In many countries, it remains the case that not all users, and particularly smaller scale, often vulnerable users, are provided with meaningful legal recognition of their rights. These uses are frequently exempted, for example, from permitting or licensing requirements. And while this can provide an important mechanism for enabling access to water for domestic or other small-scale uses, without causing an undue administrative or financial burden on the user, those exempted rights often don't have the same legal status as permitted rights, leaving them more vulnerable. Where permitting or licensing is required, for example, for small-scale productive uses or livelihoods, it's also the case that governments still frequently lack the capacity and resources to effectively implement and enforce these administrative systems across the large numbers of users to which it applies, effectively leaving them outside the protection of the law. So broadly speaking, there's a strong need for innovative solutions to the gaps left by these compulsory permitting systems, which aren't tailored to the needs and capacities of the most vulnerable users or really of the governments charged with their implementation. This principle also re-emphasizes the importance of Principle 1 on integration and coherence. The rights and arrangements that establish who has access to, can use, and manage freshwater often emanate not only from water laws, but also from diverse sectoral laws and regulations, including land, agriculture, and forest laws, among others. These, what we refer to as land-water nexuses, can provide important pathways for recognition of water rights and for guiding allocation. But where the laws are not aligned or can even contradict one another, they also leave those rights open to legal challenges and significantly undermine water security. Again, most of all for vulnerable users. This principle also calls attention to the fact that the security of many communities' water tenure rights globally hinges on the interface between customary laws and the government-issued laws that may or may not recognize those customary rights. While an increasing number of countries do recognize communities' customary water rights, this recognition is rarely specific to customary water tenure rights and rarely found in domestic water legislation. And finally, this principle highlights the need for effective recognition and protection of women's specific water tenure rights, including improved mechanisms to ensure inclusion of women in decision-making so that their unique and often differentiated water needs, knowledge, and skills are meaningfully represented. Next slide, please. Thank you. Principle 5 focuses on reiterating the fundamental importance of procedural rights and the role that they play in achieving freshwater rule of law. These include the 3 pillars of inclusive and accountable decision-making: the right of access to information, the right to participate in decision-making, and the right to access to justice should rights be infringed. Despite the long-standing global acceptance of these rights as critical pillars of inclusive, accountable, and sustainable water governance, the rights to information, participation, and justice still face huge challenges in their effective articulation and implementation, particularly within domestic water laws. This principle therefore reiterates the fundamental basis that these rights provide for achieving substantive water governance goals and calls for domestic water laws to more clearly articulate the scope and enforceability of these rights, when and how they apply, and to clearly indicate where other sectoral legal protections related to these rights apply within the freshwater context. There's a lot more that could be said about these procedural rights, but we have a very short period of time, so I'll end there. And I'll just say that we do include access to justice as one of the pillars of our procedural rights, as it is integral to understanding sort of the full context. But we've also enunciated access to justice as a separate principle to explore the broader contours of this principle in the context of freshwater rule of law. So my colleague Mike will now further elaborate on this principle and on the principle related to compliance and enforcement. Thank you.
Thank you, Jessica. Well, my name is Michael Hantke-Domas, and I'm an associate professor at the University of San Sebastián in Santiago de Chile. But as well, I'm a vice chair of this group of specialists in water and wetlands law of WCEL, a member of AIDA as well. So today I will address two interconnected pillars that are fundamental to achieving the freshwater rule of law as the other 8 principles: access to justice, compliance, and enforcement. These principles, 6 and 7, as outlined in the Manifesto for the Freshwater Rule of Law, represent critical mechanisms for ensuring that our legal frameworks effectively protect and manage our most vital resource. So despite the significant evolution in freshwater legislation over the past 50 years, we continue to face persistent governance failures. These include pollution, ecosystem degradation, lack of accountability, and marginalization of vulnerable communities' water rights. The persistence of these issues speaks to the pressing need for renewed focus on national water legislation as a key pillar of achieving freshwater rule of law. The rule of law in freshwater governance requires more than well-written laws. It requires that national water and water-related legislation provide clear, predictable, integrated, coherent, and legitimate rules and foster realistic mechanisms for the implementation and enforcement. So, Principle 6, access to justice. In this case, in freshwater governance, this extends beyond the human right to water and sanitation. It refers to the broader legal mechanisms ensuring the protection of other water uses and the environment necessary to sustain them. This is very important. Currently, many jurisdictions face significant obstacles that prevent effective access to justice in water-related disputes. Common legal challenges include restrictive standing criteria, evidentiary challenges, delays in litigation, limitations on public participation, financial barriers, lack of awareness and technical capacity, delays and ineffective remedies, and limited access to alternative dispute resolution mechanisms. The manifesto calls for domestic legislation to establish mechanisms ensuring fair, transparent, fast, and reliable access to effective administrative and judicial remedies, enforcement mechanisms, as well as alternative dispute resolution mechanisms. This is not merely procedural reform. It represents a fundamental shift towards inclusive governance. One innovative approach gaining traction is the recognition of rivers as legal persons. This grants standing to local communities and indigenous peoples with deep cultural and ecological ties to these water bodies, ensuring that their interests can be represented in court, providing an additional mechanism to protect freshwater ecosystems. So next slide, please. Compliance represents the bridge between legal frameworks and their practical implementation. The manifesto emphasizes that the freshwater rule of law calls for domestic legislation implemented by governmental and other institutions to be held accountable by all stakeholders, leading to a culture of compliance that embraces environmental and social values. Effective compliance requires several key elements. First, clarity in legal provisions that ensures all stakeholders understand their obligations. Second, integration and coherence across sectors prevent conflicting requirements that undermine compliance efforts. Third, evidence-based decision-making provides the credibility necessary for stakeholders to buy in. So the principle articulated in the manifesto states that domestic freshwater-related legislation should include mechanisms to ensure effective and compliance with and fair enforcement of its provision. This dual emphasis on effectiveness and justice recognizes that compliance cannot be achieved through coercion alone, but must be built on legitimacy and fairness. So to end, I will refer to enforcement. So enforcement mechanisms transform legal principles into tangible outcomes. Without effective enforcement, even the most progressive legislation remain merely aspirational. The freshwater rule of law requires enforcement that is both fair and effective, balancing deterrence and proportionality. So, key aspects of effective enforcement include clearly defined institutional roles and responsibilities, as the manifesto notes that domestic freshwater-related legislation should clearly define the roles and responsibilities of freshwater-related and other relevant institutional mechanisms that are involved in this implementation and enforcement. So additionally, enforcement must be supported by adequate resources, technical capacity, political will. It requires coordination across multiple agencies and sectors, reflecting the integrated nature of the freshwater governance. So with this, I will end and I will pass the floor to Zaki Shubber. Thank you.
Thank you very much, Mike. Good evening, good afternoon, good morning to all of you. Thank you for joining us today. My name is Zaki Shubber. I'm a member of AIDA and a member of the Water and Wetlands Group of the WCEL, and I'm going to talk to you about the last three principles. And I'll make some brief remarks. We've talked a lot already, and I know that you're all keen to begin the interactive section after our presentation. But before I start speaking, I want to invite you to share comments, feedbacks, and questions in the chat. We've already had one, but please continue to put your insights there. So, starting with principle 4, protection of the value of healthy ecosystems. I'm going to make 3 brief points about this principle. The first is the fact that it's focused on the environment. The other principles address areas mainly associated with human actions, interests, and rights. But as Stefano alluded to in his comments on the first principle, freshwater is firmly set in the wider natural environment, and this fact must therefore be acknowledged and reflected in the freshwater rule of law principles. Secondly, in addition to being part of the environment, water contributes to environmental and human well-being. So that value of healthy ecosystems, not just their economic or consumptive value, and the need to protect them adequately must be mentioned explicitly in the principles. Although this particular principle is the main one that deals with the environment, it's not the only one, and there is cross-referencing with other principles. The call to protect ecosystems also reinforces the injunction in Principle 2 to protect freshwater resources from pollution. Finally, and reflecting the complex web of interactions mentioned in Principle 1, healthy freshwater ecosystems are also life support systems for biodiversity, agriculture, human health, and climate resilience, and provide ecosystem services. Rivers, wetlands, and aquifers regulate water flow, filter pollutants, recharge groundwater, and mitigate the impacts of floods and droughts. Therefore, acknowledging their value and protecting healthy ecosystems ensures long-term water availability, supports biodiversity, and builds resilience to climate water-related shocks, and must therefore be clearly and normatively reflected in legislation. Next slide, please. Moving on to Principle 8, data for evidence-based decision-making. Here I'm going to make 2 points about this principle that Jess and Mike have already made reference to. Water governance is only as strong as the data behind it. Without credible and accessible data, decision-making becomes reactive, fragmented, and potentially harmful. This means that legislation must require decisions to be based on the best available data, in other words, current and scientifically credible, and it must be data that's relevant to local context. I also want to highlight the importance of making data publicly available and accessible. Making data available to the public promotes transparency, enables community participation, and enhances accountability in water management, and consequently supports other freshwater rule of law principles. And today, advances in remote sensing, citizen science, and open data platforms make this principle more achievable than ever. Next slide, please. Last but not least, international freshwater obligations. And obviously, this last principle is relevant only to those countries that share freshwater resources that cross international boundaries below and above the ground. The rationale for this principle is that measures taken in a national context have transboundary consequences on other riparian countries of a shared freshwater body. And conversely, measures taken across the international boundary lines of an international water basin will have an impact domestically in the riparian countries of that basin. The implication here is that domestic legislation of such countries should acknowledge the transboundary dimension and implications of domestic decisions regarding transboundary freshwater bodies, and should enable the implementation domestically of specific transboundary freshwater treaty obligations in the event a country has entered into such obligations. And in any case, for all countries, domestic legislation should enable the implementation of the general obligations stemming from customary international water law binding on all. And this ends our presentation of the principles. And we're now moving to the section where we open the floor for feedback and questions from you, our audience. Before we kick off, on behalf of the team, I'd like to thank those who've already contacted us with feedback. It's been very helpful and it's already inspired us. Now, you can see on the slide some questions, and they're there to give you a sense of the kind of input that we're looking for from you regarding the principles of freshwater rule of law. And to kick off this section, I'm going to read the 4 questions for you. Of course, you are welcome to make suggestions and recommendations beyond these points. So please write your comments in the chat and Q&A, and let me read for you the 4 questions. Question 1. Do you think the principles will be useful for fostering improved, more equitable and sustainable governance in your country or your context? Secondly, are the principles clear? In terms of scope and substance, is anything missing, or should anything be separated out as a principle? Thirdly, are there specific principles or aspects of them that might be politically or culturally sensitive? And finally, what types of tools might be created or leveraged to facilitate uptake of the principles and their implementation? The floor is yours. Jess.
Thank you, Zaki. I just wanted to note that we've had a few questions, some lively discussion going on in the Q&A already, and to highlight sort of what was raised, and because I think it's relevant to the broader discussion. Madi Gurek mentioned the notion of legitimacy and asking, how does the principle really provide guidance for states in terms of determining what water rights are legitimate? I answered this question, which is a really great one, by highlighting that there is a current ongoing international effort under the auspices of the FAO that we are working very closely with and part of to create principles on the responsible governance of water tenure, and we're coordinating with this effort. As Stefano mentioned in the beginning, the principles will be accompanied by an explanatory memo and guidance, and a lot of these kinds of details that would help countries really determine how to contextualize the principles like this will be included in that guidance material. So it's important to know this is sort of, to keep, in the interest of keeping the principles concise and brief, we also have a whole set of materials we're developing on these kinds of questions. But wonderful, wonderful question and something we need to focus on. Similarly, Matt Terry, thank you, noted that considerations for freshwater ecosystems, environmental in-stream flows, and ecosystem services are often not included during the allocation of water rights. Why are these non-consumptive uses not articulated in Principle 3? My answer to that was we currently have sort of a balancing approach where we have a whole separate principle that recognizes ecological integrity and in-stream flows and the importance of that as balanced with these other types of rights. But that's a great point, that both in the guidance and potentially even in a revised version of the principles, that we should make that clear, that we are including those considerations in the context of allocation. I think that was it. So we now have 2 more open questions. Would you like me to read them, Zaki?
Yes, please, Jess.
Okay. Shipra Sinha has asked, although on the face of it, the freshwater rule of law seems complementary to the BBNJ agreement. However, what happens in the event of jurisdictional overlaps, and does this lead to fragmented governance, if any? Does anyone want to take on that?
Could you recall what that acronym stands for? Because I have a vague recollection, but I'm not so sure that I remember correctly what BBNJ stands for.
I think it is the biological diversity beyond national jurisdiction. Is that correct?
Biological diversity beyond national, BBNJ. Yes, yes, sure. Well, it's probably one of those dimensions that presumably the manifesto will want to take on board. By way of, I would say, backdrop, through the reference to maybe the broader international, obligations that stem from maybe not only just water treaties in regard to transboundary freshwaters, but also the wider context of multilateral environmental treaties that may be of relevance to the scope and the thrust of the manifesto and the freshwater rule of law.
Anyone else have anything to add from the panel?
Mike?
Yeah,
Mike,
thank
please.
you. Yeah, the BBNJ is a very important treaty, just recently it's signed by the international community, which is related to marine biological protection. So it's basically an international treaty on oceans, and the main aim of the manifesto is international legislation, which is very important to make the point. We are not looking into transboundary waters, so we are very focused on national water legislation. So probably we are going to face this fragmented governance when treaties overlap, when there's an ecosystem that extends beyond the boundaries. But in this case, we are trying to focus on national governance of freshwater resources. So that's why it's freshwater resources manifesto.
Thanks, Mike. Robyn, is this specific to this question? Oh, sorry, you're muted. Go ahead.
Just quickly, it relates to this question and the question before. In terms of how the principles address ecological integrity and health. This arises, you'll see, in Principle 1 and flows as a golden thread through the principles. We see water as being the collective good of the people, as being inextricably linked to the environment and its health. So the health of freshwater resources ecological well-being, as it is said, inextricably linked to human rights or to the public good. It's part and parcel of the same package, and that is the design, not seeing the environment or ecological health as an add-on.
Mm-hmm. Thank you, Robyn. Okay, so Paul Keibel has noted that hydropower seems to present a particular challenge to principles 9 and 4 of the manifesto, to achieving coherence and integration among competing freshwater values and to the conservation of healthy ecosystems. In terms of climate change, transitioning to non-fossil fuel sources of energy can mitigate climate change impacts on ecosystems. However, hydropower can have severe adverse impacts on fisheries and biodiversity and ecosystems. How does the manifesto contribute to addressing and clarifying hydropower's place in the freshwater rule of law? Do any of my colleagues want to address that?
I guess we are trying to, incorporate and give credit to the various competing interests and values and uses of freshwater. And this is essentially what Principle 1 aims to. Now, in practice, how one does justice to the particular needs and complexities, reverberations and implications of that particular freshwater use is something that, we have to elaborate on and probably uptake in the explanatory memorandum. So this is something, actually, these kinds of considerations are of value as we take them on board, as we develop the explanatory memorandum. And in that process, maybe also, because we are open, of course, the manifesto, the principles are not cast in concrete. So it's an evolutionary process. And these kinds of considerations will be very valuable to reflect upon maybe the very wording and conceptualization of some of these principles. So I would like to thank Paul Keibel for raising this, flagging this, and this is something that I don't have an immediate answer for. Maybe other colleagues, manifestants do, but I would like, to record, this for further consideration and uptake as we further work and refine on the manifesto and on the explanatory memorandum that I announced at the beginning.
Thank you, Stefano. I would actually like to follow up on that just briefly by recalling something that Robyn mentioned and that is quite relevant to the consideration of allocation, which is the prioritization question of across sectors, across users, across uses. And this is something we've been struggling with productively, I hope, in the context of understanding how to provide guidance to countries for the responsible governance of water tenure in particular, but it really gets at this larger question of, how do we balance the various competing factors? How do we understand what externalities are involved? And I think we're creating a system for hopefully having an integrated understanding of what those are within the context of the manifesto, but that there's room for further development of kind of sort of along the lines of equitable and reasonable utilization, right? What are the factors that countries need to be considering? What are the sectors, that should be engaged in these discussions? And I think, as Stefano said, I think that's a really important thing, not only for the further elaboration of the principles to make clear that that's what we're doing, but also to provide that guidance and to look for the evidence as we continue our research at the national level across different countries to see how countries are grappling with this and to see what kind of innovative tools there are for really bringing these considerations together. And this leads a little bit into Joseph Della Penna. Joe Della Penna has a great comment. Would it be helpful to draft model legislation for consideration at the national level? I've directed development of 2 model water codes, on water allocation for use in the United States. And I would say, I personally, just really quick response to that, and then I'd love to turn it over to colleagues, is we thought about that, and in the context of the very different the diversity globally that we're looking at, we felt that this having more principles and sort of tools with which to adapt the guiding principles and the experiences from across a number of different countries would be more useful than having sort of a code that could just be taken and perhaps not really well understood or applied contextually as well across so many different countries. But I do think elements of the idea of having, model legislation in that we hope to collect sort of these lessons, these experiences, these good practices, and present them in ways that are then tailorable for the different contexts into which countries may be wanting to implement and improve freshwater rule of law. Robyn, please.
Just flowing from what you're saying, Jess, I think we need to also take cognizance of the fact that of recent times, a new mode of law and lawmaking is gaining a lot of traction. And that is what I refer to as constitutionalism, which doesn't come to be with a model law. One has to take into account the constitutional values, precepts, etc., and the like of each domestic jurisdiction. And further to what Jess said, at another level, one shies away from model legislation necessarily in view of the fact that legal pragmatism must prevail. And an evidence-based approach certainly feeds the necessary indicators for effective lawmaking and effective implementation.
Thank you. Anyone else have a comment? Okay. Our next comment is from Jorge Palencia. Congratulations. Thank you, Jorge. At the Inter-American Association for Environmental Defense, we are part of the Transformative Water Pact, which also proposes transforming principles for water management. My question concerns the follow-up of this process. What kind of tools will be derived from this manifesto, and how will it link to these existing initiatives? And I would say you have hit on number 4 here very, very squarely, that we are looking to understand where exactly things like this are happening so that we can partner and make sure that as in our principle number 1, that we are being coherent and integrated and not repeating efforts that have already been done. So it's great to hear about this effort, and we will follow up with you to learn more. Does anyone else have comments on that? Okay. Matt Terry has asked, what types of incentives are available for host countries to encourage their adoption and implementation of these principles of freshwater rule of law? Very good question. I think we're hoping that a lot of the materials and evidence base that we will be developing will show the ways in which countries can really make concrete improvements in specific areas, and the diagnostic tools and indicators will help them understand where their priorities need to be for this. But it's the beginning of a much longer process, and so right now it's sort of a longer term horizon. Does anyone want to add to that?
Yes, in fact, you spoke my mind, Jess, because actually this is where we aim at. Is the ultimate goal of the manifesto is to be, I would say, a country relevant, impactful in terms of policy and legislation and lawmaking. But it implies, engaging with countries, and that's something that we have to look to for in the further course of development and implementation of the manifesto. So it's sort of I would say, is the number 1 item on our agenda for the future of the manifesto as such, so that it doesn't remain sort of I would say, sort of an academic exercise, but it becomes, relevant in policy terms, legislative terms, in the context of any particular country. How we develop that will take up, some strategizing, and this is what lies next on our agenda, in addition to the refinement of the manifesto as a concept.
Thank you, Stefano. We are running short on time already. It's hard to believe, but I just wanted to summarize. We have 2 very, very helpful comments And then I think I'll turn it over to Stefano to close. Sharifa Ibrahim has noted in Principle 10 on the international obligations, perhaps better not to limit to international freshwater laws. There's overlap also with estuarine and coastal regime too. And that is absolutely legitimate, and we will take that on board. And then Dr. Catherine Tinker has noted that the principle, again, on international freshwater obligations is extremely important given advances through the 3 advisory opinions on climate and state responsibility from international courts and tribunals and treaties like the BBNJ. So we need to take on board these developments in international environmental law as well. Will the explanatory memo emphasize and recognize the needs for law to reflect the needs in hydrological cycle? Can the panel comment on specific principles or sources of customary international law applicable to the manifesto that states should incorporate into their national water legislation? It's a fantastic question, and unfortunately we don't have time to go into too much detail on that now, but this is something where we really encourage follow-up communication. We're recording everything here. We'll be using these questions. We'd be happy to respond and schedule a follow-up call or whatever seems appropriate to keep answering these questions. And then we have Rana Karouf just typed in, the manifesto could contribute to the compliance of countries in case of political will, especially in countries facing water scarcity. Thank you so much. So we've gotten through the comments, and I want to turn it over to Stefano to close the webinar.
Thank you, Jess. This has been, a great opportunity for not only presenting, this instrument, but collecting, as I said, preliminary feedback. This was one of the main, of the 2 main purposes of this particular event. And I sense from the feedback, however preliminary, that we received, that we are on. I think the manifesto is on track to maybe filling a gap, may I say, in regard to freshwater-related legislation, laws and regulations domestically catering for the management, conservation, development, wise use, sustainable use, protection from pollution of freshwater resources. We shied away intentionally, as was mentioned during the question and answer period. We shied away from the model legislation paradigm. We think that capturing principles for the guidance of countries would provide more useful inspiration for countries in the review, assessment, and conceptualization of legislation for freshwater resources, which again I emphasize, and the principle number 1 emphasizes, and the whole manifesto is very keen on, to bring consistency, coherence across the spectrum of human actions that impact on freshwater in different domains of activity, of human activity. This is only the beginning of a process. The manifesto, as I said, is not casting, the principles in the manifesto are not cast in concrete. We would like to further engage through with our audience through maybe additional webinars that we intend to convene as further work evolves on the manifesto, on the conceptualization of the manifesto, including the explanatory memorandum, and also through a presentation at at specific events, like notably, may I recall, the IUCN Conservation Congress in Abu Dhabi in early October this year, the International Water Resources Association World Water Congress that will be held in Marrakesh in December this year, then the AIDA Congress, which will be held in June next year in Oslo. So these are all events where we hope, to be able to further present the manifesto and attract attention to it and the principles which are encapsulated in it, for the ultimate goal of building the concept of building the concept of a freshwater rule of law with a view to implementation, with a view to its actual uptake and implementation at country level. I think I will stop here. Thank you all for your attention, patience, and for also for providing your feedback. And further feedback will be most welcome by writing at the email addresses that show on this slide. Thank you very much.